Good afternoon. This is Gloria Nelson with TUG, and it's my pleasure to welcome everyone today to the TUG Connects 365 webinar titled COVID-19 Impact, Data Privacy and Cybersecurity. We're very pleased to welcome today Nathan Steed, partner, and Kelly Hollingsworth, associate from Warner Norcross and Judd law firm. So without any further ado, I am going to turn the control panel over to you, Kelly, and I'll let you know as soon as it's visible to me. You want to go ahead and share your screen.
Okay.
And put it in first slide mode. All righty, go ahead and take it away. Thanks, everyone.
Hi, everyone. I'm Nate Steed. I am a partner at Warner Norcross and Judd. We are a full-service law firm headquartered in Grand Rapids, Michigan, with offices throughout Michigan. We have approximately 220 attorneys at the firm covering all aspects of corporate law, litigation, immigration, and Kelly and I specifically focus our work on corporate work and software licensing and technology issues and data privacy. The majority of my work is working with companies in the data privacy and software licensing area.
And I'm Kelly Hollingsworth, same as Nate. Spend a lot of time in data security and cloud solutions. So today we're going to be talking about cybersecurity and data protection, legal compliance considerations, and how that affects employee privacy, as well as third-party contracts you might need to have in place with everything that's coming up. We're going to dive right into cybersecurity, and as Gloria mentioned, feel free to put in any questions that come up as we go. We'll try to get to those as we're presenting so we don't confuse anyone, and then we'll also get to everything at the end. So cybersecurity, as you all know, it's still an issue. Cyber threats come in all different forms, and nothing's really changed based on COVID, except that the threats are getting more creative. And what we're seeing now, too, is that besides just the regular threats that are out there, everybody's had a change in routine. So now people are working from home. There's, a bunch of information coming out from different authorities on this matter. And what that does is it creates a lot of different opportunities. You get fake emails from the CDC. We have phishing emails and texts that are getting even more on point with things that are going on, malware distribution, the usual threat landscape, but with a COVID twist. So as a reminder, best practices, they don't change much. You should keep doing what you're doing and remaining diligent because the opportunities are out there. As far as your organization goes, you should, be looking at maybe the CIS Top 20 as kind of still your benchmark of all the different controls you'd want to have in place. But what we're seeing now is an increased need to keep employees informed about what's going on, all the different threats that are out there, different ways that people are being attacked, and making sure that employees know what the company expects from them. So to do that, you want to make sure that you update your data privacy and security policies and procedures to directly address work from home, working devices, etc. And if you don't have one, now is really the time that you should put one in place. And then making sure, you're still training your employees on cybersecurity and retraining them and taking this opportunity to possibly introduce some new training and encouraging reporting, right? The one thing we see happening often is that an employee might click a link and they realize that was bad, and then they just try to pretend like it never happened and hope it goes away. So, encouraging reporting and, it's nobody's fault, accidents happen, be diligent, but let us know if you suspect any activity that shouldn't be the case out there. Always good. So open communication with employees. Then this one kind of goes out the wayside of it. People say, all right, well, we've got our policies and procedures in place, we've trained our employees, we're good, but making sure that as part of your breach response plan, you've selected service providers and have actually contracted with them before you need them is one of the best things you can do ahead of time to help if there ever is a breach. You want to make sure all the relevant players have a copy of your breach response policies and procedures, and it, properly lists your insurance provider and their phone number, legal, etc. But also making sure that copy is at people's homes if they are still working from home. That was, I think, a problem at our own firm. We had to make sure everybody got their binders. But one of the big advantages of making sure you have your providers in place beforehand is just you're not scrambling to find ones in your time of need, which leads to better contract terms and better rates. Also, as far as legal goes, legal forensics and public relations, if you're working with your insurance provider to designate some of those ahead of time and make sure their fees are going to be covered, that's really helpful. Sometimes your insurance provider will even have preferred legal or preferred forensic providers, and it's good to go with them, or get your own that you prefer named. But also when things start to happen, this is kind of the order of who you should be calling. Insurance first, then legal, especially outside legal counsel, because they can really help preserve attorney-client privilege in some cases, and often help you facilitate conversations with others. Forensics if there's any investigation, and then of course public relations for everything that falls through afterwards. Okay, so best practices, these are the technical security measures focused more on those who are working from home. And when we were talking before about communicating to your employees, these are the things that you're going to want to make sure that your employees are doing. So that is, requiring the use of work-issued equipment for work purposes, or making sure, I know BYOD was huge before we sent everybody home, making sure now those devices that they're using at home aren't storing company information, making sure their programs are up to date if they're not doing work issued, and have good antivirus. Securing home networks. I think we sent something out to everybody about how to make sure their networks are secured once they're working from home, but if your employees don't have that information readily available, a couple quick tips that you could email out would be helpful, and reminding employees to not get on work material through public Wi-Fi, or enabling VPN where possible. And then the same here for physical measures, reminding employees to back up their data, and make sure that backup doesn't mean on their personal cloud space. Not storing work on personal devices, we talked about that. Getting rid of unnecessary information securely. So if somebody's printing stuff at home and at work you had shredders to take care of everything, making sure those practices are still in place, and being mindful of your space. Don't lock, or make sure you lock your devices when you're out, taking calls in private, etc. So basically all the things that you can take for granted in an office space, making sure that your employees know that those still need to apply when you're home. So that's kind of the landscape of security in a nutshell. I know we went through that quick, but you all on this presentation know what you're doing there. So if you do have any questions on that, we're happy to answer. But really, again, just keeping employees informed is probably the number one thing you can do. So we're going to turn now to legal compliance considerations. And this is all of the things that come into play when we're now moving employees back to the office, and we need to be asking them a lot of questions, potentially, about their health and what they've been up to. So here's a list of all the acronyms that come into play. I'll run them down, but you can kind of tune out. This is mostly just to show you that the lawyers know what they're talking about. So we've got the Americans with Disabilities Act, ADA. FMLA is Family and Medical Leave Act. GINA is Genetic Information Non-Disclosure Act. And we've got the Health Information Portability and Accountability Act, the EU's General Data Protection Regulations, and the California Consumer Protection Regulation, And then we say other state laws, we're really talking about invasion of privacy torts, and then breach notification laws that would come up on the state level. So when we're talking about collecting information from employees, the three laws that really apply are the ADA, FMLA, and GINA. They limit the information that you can ask your employees, and then how you need to protect that information and treat it once you've got it. So what we want to make sure is we're only asking employees about, information about their health. Have you been exposed to COVID? And Nate's going to get into a little bit more of what those questions actually are. But we want to make sure that it's only those who pose a quote unquote direct threat to the health and safety, which means this should not be something you're asking your remote workers who are not planning on returning to work. So it's something that you're really only asking people as they're coming into the workplace. Another thing, Gina has this, because it protects genetic information, it defines genetic information as family history. So that means that you can't ask somebody if they're family members or if they've been in contact with family members who have come down with COVID-19. Instead, you can ask if they've been around anyone or if they live with anyone who has COVID-19, but making sure you're specifically not talking about family members is really important there, and kind of a little bit of an annoying nuance, but just make sure. And then ADA and FMLA require that all of the information that you collect goes into a separate file from the personnel file. So that's usually their medical file. It can be where you can put all the other medical information, but it just can't be with, their general personnel file. And, that applies to both electronic and hard copy, depending on how you're planning on keeping that, if at all. And then limiting disclosures as much as possible. So as a general rule, employers need to make every effort to limit the number of people who know about the employee's identity when it relates to these questions. And that should really be confidential, except you can give that information to a public health agency. If you're a staffing agency, you can give that information to the employer. And then if you're an employee, you're saying, well, if I'm taking in that information, who do I give it out to? Pretty much your supervisor or HR, whomever you've designated as the keeper of that information, but it really shouldn't be spread further than that. And, in the event that somebody needs to leave because they've come down with COVID or are likely symptomatic, you can disclose the fact that the person is teleworking or taking leave, but you can't say why. So really just making sure you've kept that contained is very important. I should note, though, that if the employee consents to that in writing, they say, fine, go ahead, share that information with others, then you can go ahead and do so, but you should still be careful. So HIPAA, why does HIPAA apply? So a lot that we've heard when we're talking about this is, well, HIPAA says da-da-da, or, people think that HIPAA is what's governing this. But as it turns out, HIPAA is really only applicable when we're talking about information in an employer capacity that they've obtained as part of their administration of a health plan. What it doesn't apply to is just this information that you're getting, your intake when they're coming into the office and have they cleared those screening forms. So HIPAA doesn't apply there. And what that means is the HIPAA requirements for protection and breach don't apply. Now that said, you have to be very careful because you can't use, if you do have an employee-sponsored health plan, you can't use that health plan information to then see if, for example, the employee has received treatment for COVID. So that plan information needs to stay entirely separate and it can't bleed over. And then we've got some more. It doesn't end. So GDPR is that law that applies in this case to employees whose residence is in the EU. And it has a lot of protections regarding being transparent, meaning you need to let everybody know what type of information you're collecting, limit the scope of information as much as possible, and making sure that that information is secured. There's a lot of change going on lately with the different member states trying to regulate how much you can collect and what you can use it for. As a general rule, it just needs to be collected for very specific, explicit, and legitimate purposes. And then if you do do have a question about a particular country, you should check that member state because they've all issued separate guidance on how to collect that information. Now, CCPA, the new California law, which actually enforcement goes into effect in a couple weeks, we thought that might be delayed for everything that's going on, but they did not delay it. For that one, it's really about limiting disclosures it's really about focusing on disclosures and notification. So in that case, again, just letting people know what you're collecting. But there, security is really important. So you need to make sure that personal information is protected in a secure manner because that CCPA gives individuals private rights of action if there's a breach. So if you're taking on any new sensitive information that you didn't ordinarily have in, say, a medical file, or you just didn't collect this information before, you need to make sure that you're securing that information in a reasonable way and that your policies and procedures reflect that. And then finally, state law considerations. So now that everybody's working from home, their residency might change. So if there's a breach, you'll need to make sure that you know where your employees are to figure out what laws apply with respect to any breaches of that information. And also what laws apply just generally. Like, for example, Florida, the health information that you'd be collecting for screening constitutes personally identifiable information. So that then falls under the law if there is a breach. And then, California, for example, like we just said, you have to get consent to disclose that health information in a more overt manner than you would in most other states. So just making sure that your state laws are lined up and you know where your employees are is important. And now with all of that background on the laws that apply, I'm going to turn it over to Nate to talk about what that really means for you.
Thanks, Kelly. So I want to talk a little bit about a framework to help us work through how we deal with some of these issues. There's both the consideration of data that you are collecting as employees start to return to the office that is potentially sensitive, as well as information that your employees are still accessing to do their job, just doing it from a different location. And so there's a few issues that pop up when your employees are working from home, and everyone has a mobile workforce now, whether they wanted it or not. This has really accelerated some of that work from home trend that we've been seeing recently. So to what extent are you monitoring your employees' use of company information when they're working from home? And do you need to change the way that you conduct that monitoring? Does the fact that your employees are now working from home, working remotely, affect how you conduct that monitoring? Additionally, in the COVID-19 scenario, geo-tracking or geolocation use or data from cell phones may become more significant and important as far as being able to manage potential exposures. So there's some questions that you really need to ask yourself in the process. One is, have you as an employer really modified or changed what you do to monitor your employees while they're working from home? If you have, then you need to make sure that any changes are also reflected in policies that you distribute to employees. As Kelly mentioned, that was maybe an issue in the early days as we quickly transitioned to a work from home workforce without maybe the policies to keep track or distribution of those policies to track closely with it. So if new policies need to be updated to account for, or if policies need to be updated to account for new practices, then what do we need to change in our description as far as information that's collected, under what circumstances, and who can access that information that is collected, and what's the purpose of collecting that information? Again, all these need to be captured in any sort of policy revisions that you're considering making. Additionally, as you may be collecting new or different information, people are accessing or have access to that new and different information. So do those individuals need to be trained on changes to your internal privacy policies? Are there other people who are now involved in that collection who may not have been trained initially that now need to receive that training? Is there any change in the way that information is used or shared within your organization? So these are all things that you need to consider on your end as you are collecting new information or collecting information in different ways. So for on-site workers, really with COVID-19 in particular, it's important to balance really the safety aspect with employee privacy. Those are the two tensions we have in this. And so let's look at those issues a little bit more directly. So as Kelly mentioned earlier, the ADA really allows employers to make sensitive inquiries of their employees who pose a quote-unquote direct threat to the health and safety of themselves or others in the workplace. So during the COVID-19 pandemic, employers can require employees to disclose certain health information so that you as an employer can determine whether there is a direct threat to the health or safety of your workforce. In Michigan, for example, these are the current 4 questions that you can ask employees as they are returning to the office. Have they tested positive for COVID-19? Do they have any related symptoms, whether that be fever or the other ones related to it? Have they been in contact with somebody who has tested positive? Or have they been involved in international travel or on an airplane in the last 2 weeks? Every state might have a little bit of a different tweak on this, but these are the questions in Michigan that you are allowed as an employer to ask this. So states are also imposing these requirements to make sure that your work location is safe. It may be worth it to adopt a standard questionnaire to do this, that employees have to complete each day when they return to the office. And because this is really for on-site safety, this only applies to those workers who are returning to the office. As Kelly mentioned, it wouldn't be appropriate then to ask these questions of somebody who is still at home. So you really need to limit your scope to those who are returning to the office. And then you can also require employees to stay home if their answers to these questions reveal a possible infection in the process. So even though states are mandating that you do the screening, you still need to do so in a manner that is consistent with privacy laws, all those privacy laws that Kelly mentioned. So to the extent that you are collecting any of that screening data from your employees, you need to make sure that you keep that information confidential. The employees who are collecting that information need to be trained on this. They need to be trained that they shouldn't talk about these results with others. Again, it may be a very interesting point of conversation to say, oh, did you know so-and-so tested positive for coronavirus? But they need to be trained and understand that this information should be kept confidential. If you're going to have paper documents around this, you need to make sure that those are filed away in a separate location from the employee's personnel record. So it could be in the medical location. You can keep it with the ADA and the FMLA type records. But you need to make sure that that access to those records is restricted to only those employees who have a need to know. If you are collecting the data electronically, then think through who has access to that electronic record or those electronic files. Again, you need to make sure you limit those who have access to that data. You need to make sure that you have appropriate security procedures in place to keep that data confidential. And if you are using a third party, then that introduces additional concerns that we'll talk about in just a minute around the confidentiality of that information. So what does it mean to comply with privacy laws when somebody tests positive for COVID-19 or they show symptoms potentially of that disease? Well, you can ask the employee to let you know all the individuals they've been in contact with in the last 14 days within the business. So this allows you to kind of proceed down this checklist and then potentially notify other individuals that they may be at risk. Now, one thing to keep in mind and to make sure is that you need to keep the identity of that individual confidential as much as possible, or get consent from that employee if you are going to disclose the name. So once you've found out from somebody that they may have tested positive for coronavirus or have coronavirus-related symptoms, then you can disclose to other employees that they have been in contact with somebody who has symptoms or who has tested positive. Again, you're not disclosing the name of the individual specifically, but just notifying other employees within your organization that they have been in contact with somebody who did test positive. You want to make sure, again, that you document this information. And then the last point is also important, that you can disclose the name of this individual to a public health agency. In fact, you may be legally required, depending on your state law, to notify the public health agency if you have an employee who has tested positive of coronavirus. As we think through a little bit more of best practices, keep in mind the golden rule of privacy, that you need to tell people what you were doing and why you were doing it. Meaning, what information are you collecting and how that information will be used. So you want to put some of this in writing. You want to make sure that any policies that you write that are new amend other policies that don't allow for this type of information disclosure or use. It's also something you can point to if there's a dispute from an employee in the future over the nature of the policy itself. You can say, look, this new policy amended those previous ones. You want to be open and frequent in your communication with your employees. This helps prevent confusion on their end as far as the information you're collecting and what you are doing with it. And it gives employees an opportunity to comment and for you to react to those comments. I understand it's a little freaky for people when they're coming into the office now to answer some questions or to get their temperature taken, for example, when they're coming in. It feels unusual and it feels a little bit invasive, even though we all understand kind of the need behind it. So being open and frequent with your employees and your communications will help go a long way toward eliminating some of their concerns. If you're going to share the information, you want to make sure you have written permission to do so. If you want to use that employee's name when you're telling others that they've been exposed, then get that consent in writing. Again, having it in writing helps you point back to some document if there's any sort of dispute over the consent going forward. In some states like California, this consent may actually be required. So it may help you comply with state law as well. But it helps, at any rate, clarify who you are disclosing information to, again, if there's any sort of dispute. You don't need written permission to share this information with a health department, but I would say that specifically in your policy as well. Again, to aid in just being transparent and making sure there's no concerns in the future. And then also make sure that you determine what your retention time frame is. Screening data that's negative, you probably only need to keep that for a couple weeks, maybe a month total, to verify your compliance with applicable state law. Screening data that shows an infection or exposure, you may want to retain that longer just to justify your actions that are taken in reliance on that data. But again, remember, you want to keep as little data as possible because that just makes it easier to protect and less expensive, and it just creates a smaller footprint or target for potential issues that may arise in the future. So let's talk a little bit now about third parties in this space. So I can understand a lot of organizations may not necessarily want to do this themselves, either through dedicating the resources, or they just don't have the expertise to write a program that will do this, or don't want to have to deal with it manually. Either there may be more efficient ways to handle it. So because of this, there's a lot of third-party organizations that have popped up to provide the services to other organizations. There's some things to keep in mind, though, in this rapidly changing space. Some of these service providers don't necessarily have a lot of history. So this isn't necessarily bad, but it makes it a little bit more complicated when you are trying to do any of your due diligence. There may just not be sort of references that you can check with to see if this is a good provider or not. Additionally, because they've popped up relatively quickly to fill this void, contracts may not be as solid or as complete as you would otherwise expect. They're slapdash, a lot of copy, a lot of paste with provisions that may not necessarily be applicable or missing provisions that you would otherwise want. Because of this rapidly changing space as well, the timeline on getting these contracts in place is typically very tight. You need a solution in place. You have employees that are going to be showing up to the office soon or have started showing up, and you may not be able to fully vet the service providers because of the speed in which you need the agreement done. Do you have time to do a security review? Maybe, maybe not. What about a security questionnaire? Again, maybe, maybe not. Related to this is an open question as to how much a vendor is going to be willing to work with you. Again, because of the startup nature of a lot of these, they are rapidly trying to gain clients and not spending a lot of time on those that may push back. So you may lose an opportunity to sign on with a service provider if you become too bogged down in the security review. This is related to like negotiations as well. Is the agreement itself just a take it or leave it agreement? Again, the supplier or the vendor wants to get this done quickly. They may not want to negotiate much. How much leverage do you have to push back? Is it going to be an expensive agreement or not? Usually these are relatively low dollar amount agreements. They're not necessarily complicated as far as the functionality goes. And the data, while sensitive, is not social security numbers or driver's licenses or bank account numbers. A lot of these vendors, like I said, are just looking for quick hitters and will move on if they get too much pushback. So what are the key contractual provisions you want to look for? That's an open question. And many of these take the form of a mobile app, which really just compounds a lot of these problems too. It exacerbates the negotiation because it's a click-through, or maybe the agreement isn't necessarily even with you, it's with your employees. Now in this space, we see these converging trends where you have less control over your data and more liability related to that data. So there's these two trains that are basically going to meet on the tracks, and you don't want to be in the middle of it. Or, as I prefer, this classic scene from the North Shore movie, 1987, the same year that gave us Full Metal Jacket, Dirty Dancing, and A Princess Bride also gave us North Shore, where Turtle explains to his friend Rick, who is a Mainlander, how to surf half-pipe. And he explains that there's a reef out there, and he says to Rick about surfing, pipeline on the North Shore of Oahu. When the wave breaks here, don't be there or you're going to get drilled. And you don't want to be there when the wave breaks. You don't want to be in the middle. So let's look at some contractual provisions that can help protect you. Again, given the considerations we talked about above and the assumptions that we've made, that there's a tight turn, minimal negotiation leeway, and a low cost, you need to really focus your efforts on what is essential. All of these are important if you have the wherewithal, if you have the time and the resources to do it, but I recognize that that may not be the reality in all circumstances. So let's just look at a few of the quick hitters. Recognize that confidentiality and security are not necessarily the same thing. This is really an opportunity for you to focus on the definition of confidential information. Sometimes, again, because these contracts are thrown together quickly, confidential information may not account for the data that the third party is collecting for the services that they are providing. You want to make sure that it accounts for the personally identifiable information of your employees or the information that they collect. That is not just limited to what would be more traditional business confidential information. Also understand whose policies will control when we're talking about protection of that data. If you've committed to your employees certain standards as you collect that data, you need to make sure that you pass through to your third-party service provider any sort of obligations that you've agreed to that your third-party service provider will also agree to. When it comes to accessibility and the return of the data at the end of the contract, you need to think about a few things. To what extent are SLAs important for you here, service level agreements? I think it depends on the nature of the service, as it does in many circumstances. Do you need ongoing access or ongoing uptime? Or are there certain windows of availability where it's more important to you? At a shift change, for example, or at the end of the day or the start of the day, whenever that might be, do you need to make sure that system is up and running because you don't want to have a bunch of people standing around waiting to get in the front door because the results aren't processed or the service is down and they can't verify that they are symptom-free or COVID-19 free. Also, you need to think about any sort of visitors you may have that may also need to certify or attest to certain conditions and whether the system is up or down for them. To what extent will that affect you? So you have a little bit of flexibility here when you're thinking about SLAs to really focus on the windows that are important, unless all day long, maybe during working hours, is the most important time for you. Look and see if there even are SLAs in the agreement. It wouldn't surprise me in a lot of these if there aren't even SLAs at all. And then if there are remedies in there, make sure they're adequate. Is it just a refund? Is it a credit? Is the credit sufficient to entice this vendor to get the system up and running again or not? Or is termination your only remedy? If termination is the only thing you can do, that's not great in this situation because now you're left without a solution. So are there things you can do short of termination that will provide you some relief if the system isn't working? Similarly, with return of data at the end of the agreement itself, do you need this data back? As I mentioned earlier, for negative tests, you might not need it back as quickly or retained as long, but for positive information, you may need to retain that later and make sure you're getting that information back or that the vendor is going to hang on to it for X amount of days after the end of the agreement so you can substantiate your compliance with applicable law. If you're getting the data back, you want to make sure that it's not in a proprietary format, that it's actually in a format that you can access and use. And finally, the long pole in the tent of most of these contracts is liability, any limits on liability, and how indemnification interfaces with all of these. So obviously, when you're working through this, what you want to do is push for unlimited liability. Understanding that unlimited liability may be a large ask in this scenario. If you have to live with a cap, think through whether that cap is sufficient. The going rate right now for this type of data, which is sensitive information, but again, it's not like the super sensitive information that employees are sharing with you. It's not subject to Hipaa. It's not banking information. It's not passport numbers. We're looking at about $242 per individual affected. So to what extent that will cover you is an open question. And so you want to think through those specific limits and also the type of damages that you can recover. Be aware of any sort of carve-outs like consequential damages or incidental damages. If there's a data breach, that may be the lion's share of the damages themselves. The cost of notification, your attorney's fees, credit monitoring, which probably wouldn't apply here. But if it's a widespread breach, you might need to staff a call center. So those are all consequential damages, and if those are excluded from a data breach scenario, you may be left with a significant amount of liability on your end without a way to easily recover from that. Think about timing if there's a data breach as far as your third-party service provider providing you notice, and you need to think through any state breach notification laws you need to comply with to meet those. So the timing of the data breach notice to you is an important part of the agreement. And finally, as you're looking at indemnification, understand that indemnification generally applies to third-party claims. So if an employee sues you for their information getting out, indemnification would cover that. It wouldn't cover necessarily the claims that you would have directly against a third-party service provider if there is a data breach on their end. So make sure you read carefully the indemnification section and understand how that may or may not cover you and what it covers you in the circumstances of a data breach. So that's the end of our prepared remarks. We understand it's a lot of information, so we have a few minutes for questions if there is one. Gloria, you may be on mute still.
Thank you for that reminder. First question is, what are the best practices for taking employee temperatures?
Yeah, so as employees are returning to the office, it is sometimes a requirement that you take their temperature to make sure they're not demonstrating or showing any symptoms of coronavirus. Where this happens is, I think, an important consideration that because of the sensitivity of the information itself, you don't want to have a line of people waiting to get their temperature taken in the main lobby of your location. Or if you do, that there's a separate screening area. So you want to make sure that that is as private as it can be, that the results themselves are not publicly announced, or if there is some sort of verbal communication, that is outside of the earshot of others who may hear that information. So again, try to separate those individuals as much as possible as you're taking temperature. If you can do it in a more private location, that's always preferred. Again, the other issue is maintaining social distancing of people who are waiting to get their temperature taken. So you need to think through a little bit those considerations and maintaining that 6-foot separation or whatever the appropriate amount is for those locations.
Okay. I saw on our list, I'm not sure if we have anyone from across the pond, although we do have TUG members that are within UK and other countries in the European Union. I did see that we have at least one person in our midst who's in Canada. But in terms of your purview with respect to GDPA, and it applies to the European Union, California also setting up CCPA, which is kind of like the Americanized version, which is starting to trend in some other states. Even though it's not applicable in most of the lower 48, what is the time frame with regard to content removal? Because in the European Union, if somebody says, I want my information removed, they have to comply with that within, I believe it's 72 hours. And so how does that apply to the lower 48?
So it's a little different across the board. Now, typically, at least in the U.S., as long as you can justify the need for that information, you don't have to get rid of it. You might need to just stop sharing it or whatever it is. But it's more of responding to an information request. So if someone says, what sort of information do you have about me? Under CCPA, that's 45 days, and then you have another 45 days to extend that out if necessary. And under GDPR, it's a reasonable time. But really, that's a really good point in that when you're getting these requests, if this sort of information you're collecting is going into a new location, to Nate's point, when we had third-party agreements, if that's going somewhere else, making sure you can pull that information and recognize if someone has made that request, you've added this type of information to the list of sources where you would have that information.
Okay, great. And Nate, you had indicated that the only way that you could disclose the name of the employee was if you had it in writing. In times of working remotely from home and that not always being feasible, is email an acceptable form of consent to share the name of the employee who tests positive?
So the answer to the question is yes, but I would ask why you would need to test at a remote employee. So if somebody is at home and is tested positive, you as an employer don't need to know that information until that employee has either come into the office or has been in the office within the last 2 weeks. So
right, but I'm thinking if they test positive and they're sent home, and and you ask them if they want to disclose that, I guess I need to reframe that. Would then an email suffice rather than in writing?
This will be state law specific, but under most state laws, that consent through email is going to be sufficient.
Okay. I have one last question for you. We had a panel discussion last week with 3 very prominent people within our industry, and one of them had shared that an employee had come in to work repeatedly and finally came down with COVID, or excuse me, I don't think he came down with COVID. I think that it was disclosed that he had family members at home that had COVID. That required shutdown, $20,000 in expenditure with regard to cleaning and making sure that the workplace was safe for everyone else. Do companies have any recourse when employees don't share that information and incur such expense to create a safe work environment?
That's an excellent question. So I think first of all, this is an example of where you want to make sure your policies are very clear as far as what the expectations are around symptoms or family members. Like to Kelly's point, if somebody's living with somebody or shares a residency with somebody who has symptoms, that's something you want to screen for. Now, to what extent you can pass through any of that liability to your employee, I think certainly the policies can demonstrate or require or warn of disciplinary action that can occur. The financial requirement to flow through the cleaning fees, for example, is a little bit outside of my area of expertise, so I don't know the answer to that one off the top of my head as far as the costs go, but certainly you could take disciplinary action if your policies allow for it.
Yeah, and you could at least, put in your policy, we might take some recourse against you, but the specifics of that would need to be examined by an employment lawyer as far as what state applies and the exact circumstances.
Understood. Well, that concludes the number of questions that we've had this afternoon. Nate and Kelly, thank you so much for your presentation today. I'm sure that everyone who logged on found it informative. We look forward to having you continue to be valued partners in terms of your area of expertise with TUG. And I'd like to thank everyone who logged on this afternoon again to thank you for joining our TUG Connects 365 series as we continue to move along through the year. Thanks so much. And as they say in Hollywood, that's a wrap.